everybody to this week's teach-in. Professor Ralph Young in the History Department. And as you all know by now, we're having 5 of the teach-ins this semester are dealing with this theme of politics, the Supreme Court, and democracy, and which will be examining the significance of the recent controversial Supreme Court decisions on gun violence, immigration, climate change, and reproductive rights. Today's teach-in is Dobbs v. Jackson Women's Health Organization, the Supreme Court and the Future of Reproductive Rights. And we are very pleased and happy to have Professor Rachel Rebouche, who is the Dean of Temple University's Beasley School of Law, who will be leading this teach-in today. She's a leading scholar in reproductive health law, feminist legal theory, and family law. She is the author of Governance Feminism. She is currently writing a book on reproductive health law and editing a collection of essays for law and contemporary problems on the pandemic's effects on issues in contract law. Her recent research also includes articles in law reviews and in peer-reviewed journals on relational contracts, gestational surrogacy, prenatal genetic testing and genetic counseling, collaborative divorce, parental involvement laws, and international reproductive rights. So we'll turn it over to Professor Rebouche right now, and I think she's going to be, giving a presentation for a while, and then it'll be time for Q&A afterwards. Rachel.
Great, thank you, Professor Young, and thank you for inviting me to talk about Dobbs today. I am going to try to keep my comments relatively short, providing a background of Dobbs, and then thinking about how what the implications of the case have been since it was decided in June, and then opening up to questions, because I think that this is an area of law and regulation that is changing week to week, sometimes day to day. And so I think that there's a lot for us to discuss. So let me just begin by saying that at issue in Dobbs was a Missouri statute. And just actually a quick virtual show of hands, if people are comfortable, how many people have read the opinion or read some substantial portion of the opinion? Excellent. And how many people, thank you. And how many people would say that they work in or are very familiar with abortion law and policy in the US? Okay, that's great. So Dobbs concerned a Mississippi law that banned abortion at 15 weeks. When the Supreme Court took the case, many people thought at that very moment that that decision to grant cert was announced, that Roe v. Wade, the iconic 1973 case that was the bedrock for constitutional protection for abortion, that Roe was dead. And here's why. In Roe v. Wade, just as a quick background, since abortion law and policy may not be, as the show of hands reveals, is not necessarily the areas in which individuals in this group work in. Roe's a very famous case that most all of you have heard of, decided in 1973, and under the 14th Amendment, the Due Process Clause, the Supreme Court, with Justice Blackmun writing for a majority, found that in part of due process was a right to privacy. Now, privacy was a right that was also extrapolated from other constitutional amendments, but this right to privacy protected abortion at least early in pregnancy. There was a trimester framework that before 13 weeks of pregnancy, the state was at its lowest point of power in, and I'm going to keep admitting people if that's okay, Ralph. that states were at the lowest point of power in restricting abortion. So they had very little ability without some strict scrutiny, very heightened scrutiny, to restrict the abortion right. And that power of a state to restrict or regulate abortion grew as the pregnancy progressed. So in the second trimester, states could regulate to protect the health of the pregnant person, or in respect of potential life. And in the third trimester, in the latest stage of pregnancy, a state could enact powers broadly. That's where it's at the height of its power to regulate. It could ban abortion if the state deemed necessary. That trimester framework was revisited and revised in a case, Planned Parenthood versus Casey, in 1992. That case involved Pennsylvania's abortion law, and the Supreme Court there held up the law except for one provision. There was a mandatory waiting period, there was informed consent, there were reporting requirements. The only provision of Pennsylvania's act that the court struck down was the spousal notice provision, a provision of the law that required spouses to get notice when their partner sought to terminate a pregnancy. That opinion revised the trimester framework by announcing a new constitutional test that was really drawn at viability. Before viability, states couldn't place an undue burden on a person's right to an abortion. And after viability, states again were at the height of their power to restrict or ban abortion. Why is that background necessary? Well, that's the 50 years that led up to Dobbs. And when the Supreme Court took cert in Dobbs, people thought Roe and Casey were dead, because those cases had long stood for the proposition, whether or not as a trimester framework or along the pre-viability, post-viability line, that states could not ban abortion before viability. They could enact laws that were not undue burdens, which, as the Casey court told us, could include waiting periods and informed consent and detection of fetal heartbeat, and any number of regulations that courts over the last several decades had upheld. But what was commonly accepted was that states couldn't just ban abortion. So Dobbs, a clear ban of abortion before viability in Mississippi at 15 weeks, was designed to test that understanding. And I think it's important to take to just think very briefly about abortion law and policy before Dobbs. So after Casey, many states regulated abortion in a myriad of ways. So-called trap laws had been at issue in cases like Whole Women's Health and June Medical Services, the case that the Supreme Court decided the year before it decided Dobbs. And those were cases that contemplated state regulations that required hospital admitting privileges, or governed the size of counters, or required abortion clinics to be ambulatory surgical centers. Those laws, that variety of law, the Supreme Court, as recently as the year before Dobbs, had struck down as undue burdens. There had been a number of decisions that upheld some laws, struck down some laws, but had never completely banned abortion before viability. So that was the question put to the court. Is a ban of abortion before viability per se unconstitutional? And it's worth thinking that the reason to bring up trap laws and the like is that abortion access in many regions of the country had already become very strained. In Mississippi, for instance, there was only one abortion provider, and that abortion provider only provided abortions up until 16 weeks in any case. So there were these so-called abortion deserts that really characterized the country because of the patchwork of restrictions across various states. Nonetheless, Mississippi, with a 15-week ban, the court could have gone a number of directions. It could have struck down the law as unconstitutional, reaffirming Roe and Casey and the line of viability at which states could ban or could not ban abortion. It could have upheld the law under a new test. This is what Chief Justice Roberts was urged, in a sense, in his concurrence. It could have announced that the undue burden test was differently applied. So in the Mississippi context, is it an undue burden to ban abortion at 15 weeks when the only abortion provider provides up until 16 weeks? Or it could have overturned Roe and Casey in their entirety, and that's what happened. In Dobbs, the Supreme Court chucked the undue burden test, declared that states were free to ban abortion from the earliest stages of pregnancy, and the holding is that so long as states have a rational basis for regulating abortion, which, as Justice Alito says, and writing for the majority, can include banning procedures, protecting from racial and sex discrimination against because of terminations based on the sex or race of a fetus, and then broadly respect and preservation of life from the earliest stages of pregnancy. So long as a state comes with a rational basis, states can ban abortion, they can regulate it closely. So I'll keep going and then I'll pause for questions. So the meat of Justice Alito's opinion, there's really two parts in my mind. There are two aspects of the decision to consider. The first is the very long history of abortion regulation set out in Dobbs. Justice Alito, relying on a case called Glucksberg, explains that Roe and Casey were egregiously wrong the day they were decided, wrong today as the court hands down the majority decision, because abortion does not have the history or the tradition of being protected as a constitutional right in this country. The history that Justice Alito offers is to refute there had been abortion permission or abortion rights conferred at different stages of pregnancy, and instead to argue that the history of abortion law in the United States was one of criminalization and punishment. So based on a case that held that substantive due process rights under the 14th Amendment had to have a history and tradition that established their constitutional bona fides, abortion was not in that category. And so that counseled for overturning Roe and Casey as egregiously wrong. I think that's part one of the opinion, a reading of abortion law and history that focuses on the criminalization that attached to abortion to strip it of constitutional protection that was accorded to it in Roe and in Casey. The part of the opinion that I think of as part two has received a lot of attention, but there are aspects of it that I think are really fascinating and tell us a lot about the road ahead. So part two of the opinion, after the detail of history and tradition, Justice Alito offers reasons why the court should abandon stare decisis, or let it stand, the following past past decisions decided by the court, and should overturn that precedent that has existed for decades. And he offers 5 factors that the court should consider and did consider in overturning Roe. The first is the nature of the error. The second is the quality of the reasoning employed in past cases. The third is the workability of the constitutional tests that were announced, like the undue burden standard. The fourth is the disruption to other laws if precedent is disturbed and overturned. And the fifth is the absence of concrete reliance on those rights by the individuals who would exercise them. So the nature of the error and the quality of the reasoning, the disruption of other laws, Justice Alito, that relates to his exploration of history and tradition, because at the core of those arguments is that Roe, Justice Blackmun and the majority in Roe and the majority in Casey, which was actually a plurality for some issues, they just got it wrong. They got history wrong. They got reading the 14th Amendment wrong. They just got it wrong. What I think is interesting are the Dobbs arguments around workability and the absence of concrete reliance. So workability, we'll start with concrete reliance. The idea that no concrete reliance, says Justice Alito, is that this is not like a property right or a contract right. You thought you had land, you thought you had a right to be on it, then that was taken away from you and you've experienced material concrete deprivation of a right. This is very different, says Justice Alito. What's different about it? Well, if pregnancy is unplanned, how could anybody rely on the right to terminate it? It's too amorphous, says Justice Alito. And the evidence offered by the SG and by the Center for Reproductive Rights, that's not the concrete reliance we're looking for. Those groups came to court and said, the reliance that people have on a constitutional abortion right, a floor to pre-viability abortion, is what Casey said it was. It's a reliance that you'll be able to make education decisions, employment decisions. It's a reliance on a right that helps shape how you think about yourself and how you think about the control over your body. That's the reliance that the court should consider. And Justice Alito, and as a public health person, this is very interesting. Justice Alito says that's not concrete enough. Those are empirical questions that we can't possibly know the answer to, and courts can't decide. Moreover, and this is dicta, there are reasons to believe that pregnancy is not the burden that it was. There are adoption laws, there are safe haven laws, there's the Pregnancy Discrimination Act, there's the Affordable Care Act and its subsidies for prenatal and postnatal care. There's family medical leave. There's the Family Medical Leave Act that offers unpaid leave. So in this passage, we get what has been really a conversation, not just among courts about the role of pregnancy and the role of abortion restrictions, but two very different visions that played out in the course of movement politics around those questions too. Workability, I think, is interesting for where we have been since June. So workability is the idea that the cases that came before Roe and Casey in this situation created tests that were too inconsistent. They deepened the conflict. Courts produced disparate conclusions based on similar facts. The tests themselves were too fact-driven. They weren't workable. Well, interestingly, I think that what we're seeing is that returning abortion law to the states has its own set of workability issues. So what's happening now is, in the aftermath of Dobbs, 12 states, this flickers with state laws getting enjoined week to week and then being put back in force. 12 states prohibit abortion at early stages of pregnancy. They vary in what exceptions they allow. Texas, for instance, has an exception for medical emergency in life, but no exception for sexual assault or to protect or safeguard the health of the pregnant person. There's wide variation across states now about what their policies and how those policies apply in those states in regard to abortion. Many believe that at the end of the year and in the year or two to come, about half of the country will ban abortion to some extent, different points of gestation with different exceptions. At the same time, you have states that have been proactive in advancing abortion rights. So 15 states already had statutory or constitutional protection for abortion rights. More states are passing laws or voting on ballot initiatives that protect abortion access. The most notable of those are states like Massachusetts, New York, Connecticut, Delaware, California that are passing shield laws. These are in anticipation of what many believe will be laws that penalize people who provide abortion to out-of-state residents of other states in which where abortion is illegal. So these shield laws the state, like Massachusetts, refused to comply with subpoenas or depositions against providers or people in-state offering in-state abortion services. They refuse to extradite so long as the person is not fleeing from justice. They give providers a right to countersue if they're the subject of a lawsuit or criminal charges from another state. And there's reason to believe that this is a direction states might move. States like Texas are considering civil lawsuits and professional discipline for providers out of state that are assisting Texas residents with abortions that would violate Texas law. Some of those proposals mirror SB 8, which had been went into force before Dobbs, which creates a civil cause of action brought by a private person to sue a provider who's in violation of a 6-week heartbeat ban with a $10,000 penalty. States like Georgia have enacted, brought back into force a 2019 law, which defines a natural person as a being at conception. So there's a personhood clause that's now in effect. And there's a lot of conversation about whether or not there is a ordinary criminal law can be used against someone who travels out of state to terminate a pregnancy and comes back into the state and is charged with the murder of a Georgian citizen. So those are all examples to suggest that the legal landscape is complicated and it's changing day to day. Add on top of that, this interstate conflict, which I think in Q&A we can talk about the ways in which that's really tests constitutional rights to travel, privileges and immunity, dormant commerce clause principles, but also just core principles of federalism and comity and cooperation between the states. Add on top of that, what we've also seeing an interjurisdictional conflict. The Biden administration taking measures to pursue potentially arguments about preemption, the role of federal statutes in protecting emergency care or patient privacy, and states resisting. Texas, Idaho, conflict between states and the federal government as the federal government seeks to protect abortion access with federal tools. So I've been talking for a while. I'll just add in conclusion one more layer of complexity, which is the emergence and growth of medication abortion. So I'd love to talk about this more in Q&A, but in 2020, a district court lifted an FDA requirement that patients pick up mifepristone, the first drug in a medication abortion. Medication abortion is a 2-drug regimen that the FDA has approved before 10 weeks of pregnancy. And the FDA had a requirement that someone pick that up at a healthcare facility, even though they could take it at home. During the pandemic, a court enjoined that rule. And after in the spring of 2021, the FDA permanently lifted it. So telehealth for abortion has proliferated because now you can have an online counseling session, synchronous or asynchronous, and then have medication abortion mailed to you. Once pills are in the mail, they're hard to track down. And that's been the experience of an entity called Aid Access, which operates outside of this model and will mail pills to anyone in the US in any state. This is often considered self-resourced or self-managed abortion, but I raise it to say you have not just a complicated legal landscape, but you have an increasingly complicated set of questions around access. And in the meantime, states and localities, movements, figuring out who they are and what their goals are in this fast-changing legal and practical atmospheres. So I'll stop there.
Okay, thank you, Rachel. Let's get into some Q&A. If anybody has any questions, just raise your hand, virtual or real. Certainly a lot to talk about. Brianna.
Hi, I hope you can hear me well. I'm on the roof of the CLA building and it's a little bit windy. Um, okay, you can hear me?
Yeah.
Okay, beautiful. So first of all, thank you so much. I learned so much. I did not know that much about the actual legal background of this case. I had one question that's kind of outside the scope of directly what you talked about, but I'm just super curious about it. So my impression was that Dobbs v. Jackson and the overturning of Roe versus Wade also had to do with states' rights versus federal rights. And I don't know, I saw that Senator Lindsey Graham was talking about a federal ban on abortion after 15 weeks or something. Does the ruling of Dobbs v. Jackson, does that do anything to address that? Because isn't it taking abortion out of the hands of the federal government? I just don't know that much about it, so I would love to hear more about it.
It's a great question. Thank you. So at the heart of Dobbs, and I didn't mention, I might say a few words about Dobbs in relation to other constitutional rights. But at the heart of Dobbs, the returning to the states, that rationale was that Roe and Casey, what they got wrong is they took out of states' hands the ability to respond to their voters and their populace and their beliefs about abortion. Because what a constitutional right does is it precludes states from banning abortion before viability, for instance. So at the heart there is not necessarily about states versus the federal government, but about the Constitution commandeering states' ability to regulate and respond to beliefs about abortion within their borders. So whether or not there's a federal right is not something that the Supreme Court explicitly contemplates. But according to the reason of Dobbs, Justice Alito says the reason we give this to the states is because voters should decide. If you don't like your abortion law, go to the polls and vote out the people who wrote it. The same kind of thinking applies to a federal right to or a federal ban against. If you don't like what the Supreme, if you don't like what your state is doing, elect Congress people who will write and pass a law that does X. Because if the federal government passes a law that is a ban, the Graham ban, let's call it, then that will preempt state laws. So this is also the thinking between the Women's Health and Protection Act. The same idea that if Congress passes a law that creates a federal statutory right for abortion, then that's going to preempt the state bans. And that's a different tension, right? The Supreme Court didn't weigh in to say that the federal government doesn't have a right to legislate abortion. It was concerned with Roe and Casey and what those cases did to create a constitutional floor of protection that disabled, didn't enable states to enact policies that contradicted that federal protection for pre-viable abortion. Does that make sense?
No, that makes so much sense. Thank you so much.
So, but the interesting question that raises is, so before Roe and then after Roe, there was a big push for a federal ban on abortion. It lost. But the really big push was for constitutional recognition of the right to life from conception, that a person should include a fetus under the Constitution. There, I think, is a tension. If the Supreme Court were to decide that the Constitution confers a personhood on a fetus, it would arguably doing exactly the thing that it said Roe and Casey were in error in finding a right that would deprive states of offering abortion services within their borders or to residents. Now, I can see how it could happen. It would have to be a history and tradition of fetal recognition. that itself, I think, would be as contested as the history and tradition offered the contrasting history and traditions offered by the majority in dissent in Dobbs. So I'll say one quick thing about that. So the due process clause, the right to life, liberty, and property should not be deprived without the due process law. It's in the 14th Amendment, applies to the states. In case for the non-lawyers, there's a procedural aspect of that, right? The procedural aspect is no arbitrary deprivation of life, liberty, property. But what's been very controversial, and what Roe came to stand for in some ways, as other cases did too, is a substantive due process right, which is that those words, the right to liberty, for instance, is more than just the right to be free from arbitrary imprisonment. It encaptures some fundamental freedoms that are core to how we think about the ways that we govern our lives. The earliest cases establishing a liberty interest, a fundamental freedom that was protected by the Constitution that would strike down state laws, were in cases where the Supreme Court struck down state laws that tried to interfere in the parent-child relationship. These are early cases in which Nebraska tries to, I think it's Nebraska. Did I get this wrong? I'm gonna get the states wrong. Where a state seeks to ban German being taught in schools, or seeks to direct parents that have to send their children to public schools. I think that was an Oregon case. And the Supreme Court interpreted the 14th Amendment due process clause to have this substantive nature, that there are some rights older than the Bill of Rights that are core to who people are. And that has been applied to the right to marry. So both in the right to marry without, so in Loving versus Virginia, that was an equal protection question too, the right to marry someone who is not of the same race that you are, striking down miscegenation laws, the right of couples of the same sex to marry, 2015, Obergefell, that's been those substantive fundamental freedoms have been applied to contraceptive use, Griswold and Eisenstadt, that is core, that kind of intimacy, that kind of self-bodily autonomy is older than the Bill of Rights, to intimate conduct. What kind of intimate conduct that you engage in. And there's now a very live conversation about, well, hold on, if abortion doesn't have a history and tradition of protection under the Constitution and has one of criminalization, well, does it contraceptive use too? Could states ban birth control if a court found that, like Roe and Casey, there shouldn't be constitutional protection extended to rights that are not explicit in the Constitution? Justice Alito goes out of his way. I think he says 4 times, no other right is under threat. This is just about abortion. And the reason that abortion is different is because it involves potential life. The dissent says, not so fast. And Justice Thomas, writing a concurrence, says, I'm for getting rid of all of it. Let's revisit all those rights and see if there's a more explicit place in the Constitution that protects them. And the dissent, saying, how can you parse the distinctions? So there's a lot of conversation about what comes next.
There's a question in chat. You mentioned the states have to have rational reasoning to ban abortion. Is there an actual legal standard for what is rational, or is that deliberately vague?
Thank you, Lizzie. Shout out to Lizzie from the Law School Library. So it has been spelled out in a series of cases. but here's how I tend to think about it, and I like to explain it. So there are these levels of scrutiny, and rational basis, and the levels of scrutiny is generally a framework with how closely are we going to look at what the state's doing here. Here's the rights, here's what the state wants to do, or here's the objective of the state. How closely are we going to look at that and see? If it's strict scrutiny, we're going to look very closely. If it's heightened scrutiny, we're not going to look as closely. If it's rational basis, that's essentially the lowest form of scrutiny. And how it's been interpreted over the years is essentially a laugh out loud test. States, so long as they are not being truly arbitrary, irrational, though there has been some flicker of rational basis with teeth, where a rational basis test has been used in Lawrence versus Texas to strike down a sodomy law because of its disproportionate enforcement, its use of criminal law. But generally, and this is the line of cases that Justice Alito cites in Dobbs, rational basis, so long as the state can come to court and give any state interest in doing what it's doing, then the law should stand. And Justice Alito, to give some, I guess, clarity for what rational basis might look like in the context of abortion, has a passage that says, rational basis such as, and those are some of the examples that are giving, the first one of which, a state has a rational basis, has a legitimate interest in respecting and preserving life from the earliest stages of pregnancy. And that's pretty broad. That's pretty broad. So there's a chat to me, and it's asking, can I go over the 5 reasons? I'll just say them again quickly. Again, these are the factors that Justice Alito enumerated to suggest why precedent should be overturned and why stare decisis shouldn't be respected. And they're the nature of the error, the nature of the error of the previous cases, the quality of the reasoning of those cases, the workability of the test or standards announced in previous cases and precedent, disruption to other laws. So if you overturn Roe and Casey, would it have a ripple effect that we would have to undo and rethink doctrine for any other host of fields or standards? And then absence of concrete reliance.
Any more questions? Don't be shy. As I mentioned earlier, you can put something in the chat too if you don't want to actually speak.
So I think Bethany has.
Hi.
Okay.
Can you hear me okay?
Yes.
Hi, I'm a PhD candidate in the sociology department. I was just curious with something you said at the very end there about medication abortions, because a lot of times for medication abortions, you take one pill in a clinic and then you take the other one at home. I'm curious about if you know anything about the legality of crossing state lines, and if the legality of taking it resides in where it's originally obtained at that first pill, or if it's where the actual second pill and then the actual body processes happen if the states have different legal or have different laws around abortion.
Yeah, it's such a good question. So, and it's even more complicated because you could take both drugs in another state at home. But right, so so just a quick, this might be more information than necessary, but I think it helps illustrate Bethany's very good question, which is, so mifepristone is the first drug, and you take that drug, and that is what stops the progesterone. It sheds the egg from the lining, or it keeps it. It doesn't enable a fertilized egg to implant and develop. It's a hormone. Then 24 to 48 hours later, you take misoprostol, and misoprostol is a drug that's not regulated like mifepristone because it can be used for other purposes. Mifepristone is the only drug approved to end a pregnancy by the FDA in the United States. Misoprostol is approved for ulcers and other conditions, but what it does is it causes the uterus to contract and expel the uteral lining with the fertilized egg. And that's why a medication abortion has to be early. Now, it has been used up through 13 weeks in an off-label capacity, but it's only approved for 10 weeks. So there's not even just one pill here, one pill here. Almost everybody is going to take at least misoprostol at home, because even if they pick up mifepristone, they're not waiting in a clinic 24, 48 hours later, and they don't need to under current rules. So the question of where the abortion happens is now a very live one. If I drive from Texas to New Mexico, I pick up a medication abortion at the border at a mobile clinic, and I take them all back, or just the misoprostol back to Texas. Am I having an abortion in Texas? And that is a live question. Most providers believe that the care occurs where you ingest it. So if you take the mifepristone, that's where the abortion occurs. And indeed, that's what sets off the chain of events that ends the pregnancy. The misoprostol can also be used by itself to end a pregnancy, but the mifepristone is what stops the development. But that's not to say that Texas has to recognize that as it passes its laws. It can define an abortion as happening wherever a pill is ingested in state. And so that, I think, is a reason I'm really interested in that question, is because I've been doing research on just these questions of movement and regulation and mail and the like, and it's not clear. Massachusetts, for instance, as I mentioned, has passed a SHIELD law. And in that law, it defines reproductive health services as a set of services, blah, 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 regardless of where the patient resides. So it's changing the standard of care in some senses to be defined as where the provider is, not where the patient is, which is a follow-up attendant question to yours, which is, how are these definitions going to change and shift based on the abortion politics of the state?
Right, there's a question in chat, but also Jennifer has her hand up. Why don't we go to Jennifer, and maybe Brianna, you can phrase your question after Jennifer.
Hi, Rachel. I'm Jen. I teach in the GSW, Gender, Sexuality, and Women's Studies program. We're so excited to have you come speak for us.
You're going to hear some similar.
No, I love it. I love it. This was such a great, I'm so glad to be able to come here today. So pardon me, I'm not an attorney, so I might mess this up. It'll come out a little bit clumsy, but I'm wondering if there's a relationship between the EPA decision and Dobbs in that taking administrative authority away, or taking authority away from administrative agencies, kicking it back to Congress, who's not an expert in those areas. And then there's gridlock, but then saying, well, it's not our fault, stuff's not getting done. Congress isn't doing anything. And then Dobbs taking authority away from doctors or experts, who I listened to a New York Times conversation a month ago, and there were some doctors and attorneys talking and saying, in the actual moment where a woman's life is potentially at risk, right? And now the law is trying to define, or doctors are trying to figure out, when is that moment? You know, the doctor was saying, do I call the general counsel for the hospital? Like, do I call my attorney first to make that decision? And then does the attorney like call the state legislator to figure out like when it's okay to do this? And so again, taking authority away from the expert, putting it in the hands of someone else. But then if the woman dies, saying, well, it's not my fault, the doctor should have saved her life. So I'm just wondering how you understand maybe it just seems like there's a common thread there, but I'm not sure if I'm getting that quite right, or understanding either of the decisions fully.
No, it's really interesting. So I think I do think there's I think there's potentially a thread, but I think there are also consequences that overlap between what has been, for many, how many have described as the dismantling of the administrative state. And the bigger, broader question that I think your point really gets to in such a salient and timely way is, who is the expert and who deserves to decide questions in this area of what a medical emergency is, of what care is required by state law, federal law, or a set of agency guidance. And just to take your point, so the EPA decision has, I think, implications for what the Health and Human Services, what the FDA, the actions that they're taking now to apply federal standards on states that are contradicting those federal standards. And I think we've now seen courts in Texas and in Idaho with clashing decisions around the Emergency Medical Treatment and Active Labor Act, EMTALA. So that's an act, just as the example for your question, that defines what the duties of ER doctors and ER and hospitals are for a patient that presents an emergency. And just as you pointed out, there have been high-profile instances where it's not clear to anyone what the state law requires in terms of treating someone who presents with an ectopic pregnancy and needs care, who's in the middle of a miscarriage. Do they wait till the pregnancy is lost and then intervene? And in some cases that has profound health effects, has threatened people's lives. There will be, as many predict, there will be mortality consequences for those decisions. And that the Biden administration intervened with EMTALA to say, look, state of Texas, you don't get to be the arbiter of what happens in a medical emergency. We have a federal act that trumps your state law about what emergency departments have to do. And the Fifth Circuit, which is the appellate court for Texas, disagreed and said, no, actually, it's Texas law. The same problem, the same controversy happened in Idaho. And the Idaho, and I may have got that wrong, it may not be in the Fifth Circuit yet, it could just be in the district court. But the Idaho court said, no, EMTALA governs. It's the federal government that preempts or takes precedent over state law. So that question is going to go potentially to the Supreme Court, because now there is a split potentially between courts. And EPA is important for the court deciding how the Biden administration, acting through an agency, can advise and guide states around their abortion provision.
Right. And my last little tiny follow-up to that is, I'm wondering if that was strategic in being able then to relinquish responsibility for bad outcomes.
So say more.
So now with the EPA decision, right? Like, oh, well, it's not our fault because Congress can't act. We didn't take away total authority. That's not what we meant. That's not how this works. And so they can grind. So the EPA decision can grind things to a halt. But those who upheld that, or those who put that decision in action, can relinquish themselves of responsibility and accountability for any bad outcomes. And then with Dobbs, taking authority away from the expert, the doctor, but saying, but if there's a bad outcome, we're not responsible for that either. So it seems like there seems like a strategic component, or consciously or unconsciously, to also relinquish the actors from any bad outcomes or negative consequences.
It's interesting. It's interesting because the portion of the Just Go Vote of Alito opinion has received a lot of criticism from people who write about gerrymandering and voter restrictions, and as if so yeah. So
thank you so much, Rachel. I really appreciate that.
Well, when I come to Ginger Studies, just let me know what you didn't like. I'll change it.
That was perfect. Perfect.
Okay, Brianna, did you want to ask your question that you put in the chat?
Yeah, of course. So again, this is like a little bit abstract, but I was reading these articles about different theories of discrimination, like a liberty-based discrimination versus equality-based discrimination and stuff like that. And in my philosophy of law class, someone mentioned that like a ban against abortion could be an infringement. It could be an act of discrimination because it only infringes on the rights of people who are able to get pregnant. But then we didn't really talk that much about it. So I don't know. I was curious about your thoughts on it.
Sure. So, that there's something really interesting happening now post Dobbs. There is, I think, renewed thinking about what are other avenues to not just advance abortion access, and that's, I think, where medication abortion is playing a more prominent role. But what are legal strategies or arguments that would secure abortion rights? So this is a little bit of a long way to answer your question, but on the state level, you see this happening where state courts are enjoining state abortion bans under state constitution provisions. So some states have their Supreme Courts have interpreted state constitutions and their equality clauses, as well as bodily autonomy and the like, as protecting abortion rights. So there's an experiment, there's activity happening there. And it's interesting because for some time, there's a cohort of scholars and lawyers who have really pressed that abortion rights, in addition to due process or in the alternative to due process, that abortion rights should be protected as equality rights under the Equal Protection Clause of the federal Constitution. That really has gotten nowhere in federal courts. And Justice Alito, interestingly, devotes a paragraph to talking about why that's a non-starter, why the Equal Protection Clause does not protect abortion and never has, and the like. He cites a case that was the impetus for the Pregnancy Discrimination Act, of why decisions about pregnancy in this way are not sex discrimination, are not protected in the same way as other suspect classifications. Interestingly, he also then cites the Pregnancy Discrimination Act, which overturned that case later in the opinion when he's talking about why pregnancy is not a burden. It's not a burden. But you're right to suspect that there is a lot of there's been support and a lot of conversation about other ways to ground abortion rights in principles like equality, or instead of just privacy or liberty or bodily autonomy.
Okay, there's another question in the chat, since from Christina Elliott. Would Christina like to read her question, or should I do it? Since certain states have passed temporary bans, it has become an option for people to travel state lines to receive abortions. Is it possible to ban a state resident from having an abortion even in other states? I think you kind of talked about that a little bit.
Yeah, so this is, I think, a really, this is going to be a contested area. There are good reasons to believe that if a state like Texas tries to apply its law extraterritorially, tries to apply its abortion ban directly or indirectly outside its state lines, our federal constitution prohibits Texas from doing that. There's lots of arguments you could make. States can't interfere with interstate commerce under constitutional provisions. There's a similar due process type claim to a right to travel of an individual. There's an underexplored and underutilized privileges and immunities right. But with two co-authors, I've done research on how those constitutional provisions could apply, arguably should apply, but it's not clear at all that the court would apply them, and they have not been applied in the abortion context. Some of them are very underdeveloped, like privileges and immunities. And so you have states like Texas, the Texas Freedom Caucus, issuing letters to Sidley Austin, which is a major law firm, essentially spelling out that in the next session, the session coming up, they are going to try to pass a law that seeks to punish providers out of state who provide abortions to Texas residents. And they know it's probably unconstitutional, so they're going to probably try to pass it as an SB 8 style law. Well, I mean, this is the plan. This is what they've said in the letter, which might make that immune from review in a federal court for the same reasons that courts refuse to consider the constitutionality of SB 8 because of standing. So, I think that there will be a lot of contestation. I think you'll see some courts strike down those attempts. I think some courts may not.
Okay. Any other questions? I mean, there's just so much, just your presentation that my thoughts are just going in all sorts of directions because of the complexity of all the things that have been unleashed here. Let's see, any other questions coming in at all?
Well, just want to say thank you all for coming, and I've enjoyed the conversation. I want to say thank you again to Professor Young, and my email is my last name at temple.edu, and looking forward to continuing the conversation.
All right. Well, thank you again so much. It's been really a pleasure having you, and a very great learning experience for all of us.
Cool.
And
Thank you.
all right, ciao, everybody.